Good afternoon, ladies and gentlemen, and welcome to our webinar on efficiency as a service, contractual framework, energy policy, and property law. Today's webinar is the second of a series of 3 capacity building webinar we are organizing in the context of the efficiency as a service project. In our first webinar on the successful path to servitization, we looked into the market trends, challenges, and key success factors in relation with the transition to service-oriented business model. In today's webinar, we will look into the transfer of risks associated with the implementation of an efficiency as a service agreement. We will also dive a bit deeper into the Belgian property law and the associated potential risk of loss of ownership of the equipment. We will present to you the efficiency as a service standardized agreement that was developed in the context of the project. And we will also look into the latest development in energy policy law and possible implications or opportunities that these could create for efficiency as a service agreements. My name is Mira Taya, and I'm a circular economy expert here at Agoria. And sorry, I saw that there was a problem with my slides. Agoria is the Belgian Federation of Technology Companies, and I'm joined by Dimitris Karamitsos, who is Senior Energy Efficiency Business Developer at BASE, the Basel Agency for Sustainable Energy. Dimitris and I will be your host and moderator for today's webinar. As I mentioned, this webinar is organized in the context of the Efficiency as a Service project. This project has received funding from the European Union Horizon 2020 Research and Innovation Program and aims at accelerating the market adoption of energy efficient solution within enterprises through a pay-per-use as a service business model. The project is taking place in Belgium, in the Netherlands, and in Spain. Agoria is the country coordinator of the project in Belgium, and you can see our consortium partner at the bottom of the slide. ANESE, which is the Spanish ESCO Federation, is coordinating the project in Spain. EIT Inno Energy is the coordinator for the project in the Netherlands, and BASE is the overall project coordinator. I'm very pleased to welcome our today's guest speaker. Our first speaker is Benjamin Verheijen. Benjamin is a postdoctoral researcher and focuses his research on law and technology and law and sustainability with a special attention to real estate law. Benjamin will talk to you about the Belgian property law and the implications with regards to efficiency as a service agreements. Our second speaker is Beatrice van den Abele. Beatrice is a company lawyer and has been working at Agoria for about 10 years. She focuses on business and competition law and provides legal advice to Agoria member company. She also carries out advocacy and monitoring of legislative initiative. She is involved in circular economy projects with regards to the contractual aspects and also legal questions that derive from the adoption of new business models such as servitization. Beatrice will present to you the efficiency as a service standardized agreement that was developed in the course of the project. And our third and final speaker is Ruth Lambrecht. Ruth is an energy climate policy expert and has been working for Agoria for about 9 years. She focuses on the regulatory framework of climate policy, energy market, and energy policy legislation. As a project manager for Fit for 55, Ruth is also heavily involved in the European energy legislation and its impact on Belgian technology companies. Ruth will share with you the latest development in EU energy policy, but also how it is being currently implemented in Belgium regional policies. So some practicalities. This webinar is being recorded. There will be a Q&A session at the end of the webinar. So you can use the Q&A function at the bottom of your screen if you have any questions for the speaker. So even during their talks, you can enter your questions. Your microphones have been muted, but please, if you wish to voice directly a question or a comment to the speakers at the end of the webinar, you can raise your hand and we will unmute your microphone so that you can voice your comment or your question. Before giving the floor to Benjamin, I will just give a very short introduction with regards to the shift of responsibilities and of risk in the adoption of an efficiency as a service agreement. So if we look at a traditional sales model, the customer is responsible for the design, the selection, and the installation of the equipment, also responsible for the financing of the equipment, obviously, everything that is regarding the performance, the maintenance, and possibly the monitoring of the equipment. When moving to an efficiency as a service business model, all these responsibilities shift to the supplier. So it's actually the efficiency as a service supplier that is responsible for the design of the equipment, for the installation of the equipment, for the financing of the equipment, but also for everything that is related to the operation, the maintenance, the performance of the equipment, and as well as the end of life of the equipment. So the service provider, or the efficiency as a service provider, I would say, takes care of everything and offers a single solution to the customer. So the efficiency as a service solution, and the customer pays a single monthly fee. Within the project, we've developed a pay-per-use model. However, there are various types of agreements. It can be pay-per-saving, it can be also fixed monthly fee. Within this, the contract, or within this project, we're focusing on a pay-per-use model. So when looking into the responsibilities, the fact that all the responsibilities have shifted to the supplier, there's also obviously the associated risks that are not now shift to the efficiency as a service provider, and also some new risks that will appear on the customer side. So what kind of risks? If we look at so on the left-hand side, you have the customer, and on the right-hand side, you have the efficiency as a service supplier. So on the customer side, new, I would say, risk that appears in efficiency as a service model is the risk of discontinuation of services. For example, if the supplier runs into an insolvency situation. So here the supplier provides the equipment, but is also responsible for the operation and the maintenance of the equipment. So there is this risk that appears for the customer. Also a risk in terms of lock-in. Some efficiency as a service agreement can be really very long-term agreement. We can, in cases, talk about 10 years or 15 years of contract between the supplier and the customer. So there is a potential concern from the customer side that he could be locked in for a very long time with a single supplier. Also efficiency as a service, and the same way as many as a service business model, will come with a number of collection of data. So the provider will be monitoring a number of parameters from the equipment side, but from also the consumption side. And so there is a number of data that will be managed and collected by the supplier. And so there will be a concern also on the customer side with regards to the management of this data. If we look at the supplier side, one of the main risks is really regarding the financial aspects. Now this is the supplier, because there is no transfer of ownership between the supplier and the customer. The supplier is responsible for the financing of the equipment. So the credit risk is now on the hand of the supplier. We talk about also the servitization paradox. We talked about this in our first webinar. In short, the supplier, it's a new business model, and the supplier has to make some investments in order to provide the adequate services to the customer. And should a technology provider be implementing an as a service business model for the first time, or a new technology where perhaps the servicing cost might not be well known, there could be some costs that are unexpected or higher than what were expected, and this could cause a bit of a constraint on the revenue model of the business model, and also the impact of the balance sheet because of the fact that there is no transfer or ownership between the supplier and the customer. Another risk, and because we're talking here about a pay-per-use model, it's the volume risk. associated to the fact that there could be in some circumstances where, for instance, the customer business is on hold. We've seen this during the COVID period. So if we're working on a pay-per-use contract, this could mean that for some time the customer would not be paying fee for to the supplier, and we see how we can sort of a bit mitigate this risk. Again, technical and performance. Now it's the supplier that is really responsible for the performance of the equipment, for all the technical aspects. Within agreement, there are some service level agreements. So the supplier is required to perform according to a certain service level. And therefore, if there is, in case of lack of respect of these agreements, there could be some penalty fee that will apply to the supplier. And an important risk also that will concern some of the equipment is the risk of loss of ownership. I will not delve into this because Benjamin will talk about this risk in a couple of minutes. So before giving the floor to Benjamin, just one last part. Here we looked into a bit the balance between the supplier and the customer in terms of a bit the risk distribution. But in reality, most of the efficiency as a service agreements will imply a tripartite relationship between a financier, a service provider, and the final customer, which means that there will be also a sort of redistribution of risk between the service provider and the financing institution. We will explore this further in our third and last webinar this Thursday. Benjamin, the floor is yours.
Thank you very much, Mira. I will simply start by sharing my screen. There we go. Indeed, good afternoon to everybody. Also on my behalf, it's a pleasure to be here. Thank you to the organizers for inviting me. And indeed, during my talk, which I promise to keep as brief as possible, I would like to discuss some aspects and some risks of the circular economy, thereby focusing mostly on real estate. Why the focus on real estate? Because yes, of course, on the one hand, it's the area of the law, the branch of law with which I'm most familiar, but also from a more practical and pragmatic point of view, because the real estate sector is one of those sectors that are, on the one hand, very energy consuming, so not always as sustainable as we would like them to be, but, and that's more fortunately, on the other hand, the real estate sector is also focuses a lot on sustainability nowadays, and it is one of the sectors that is very interested in the circular economy. So there are some opportunities, but of course, in order to enjoy these opportunities, we must have a very close look at the various threats that exist. The various challenges, because these threats must of course be mitigated, otherwise no real estate actor will ever get really involved in the circular economy. The first part of my talk was a brief introduction, a brief overview of some core ideas of the circular economy, but given your presence at this rather specialized webinar, I dare to assume that you are already quite familiar with the essentials that are lined out on my PowerPoint slide. The only thing that I'd like to say that, of course, we have various ways of operationalizing the circular economy. The lease operationalization is not the only one, but still, I remarked that in the real estate sector, it's one of the operationalizations that is most looked into, which is why I would like to limit myself and this talk to the service providing model through lease. And when I say lease, I really mean the common lease, and it is very well known in the real estate sector. The advantage of focusing on lease is, on the one hand, the fact that it is commonly known, so that real estate actors feel rather at ease when talking about lease. But on the other hand, also it offers a kind of legal certainty, It offers a kind of legal certainty not only to the lessor, but also to the lessee. And of course, that legal certainty is one value that must, at all times, also when talking about servitization of real estate, it's a factor that must be on top of the list of values that must be protected. As I already told you, the real estate sector is very interested in sustainability. It has already developed past few decades a number of concepts, the life cycle costs, then the various labels, sustainability labels that are very well known in the real estate sector. I think of BREEAM, I think of Lease, and of course, the real estate sector is not only interested in sustainable real estate for marketing, from a marketing perspective, which is, however, the only bullet point that I mentioned on my slides for practical reasons, but also circular real estate might have a huge impact on the profitability of the real estate sector. As a matter of fact, there are certain studies available that suggest, or at least seem to prove, that the real estate sector might benefit a lot from turning itself into a more sustainable and more circular market. And of course, this higher profitability is also one of the key arguments to convince real estate actors to turn themselves into a more circular company. As we are speaking, a number of projects, and I only name a few, but dozens of projects for circular real estate are already up and running, as a matter of fact. One of my favorites is the MUs and M0 project. And why is it my favorite? Because it's an example that I'm rather familiar with. It's the Mitsubishi elevator project. And what is the Mitsubishi elevator project? Well, as a matter of fact, Mitsubishi offers its customers the opportunity not to buy an elevator, but to lease one. And I know that this is also a very particular topic on which Agoria is conducting some research, especially for the elevator market. But then, so what you should remember, that we are living in a world in which it is in fact possible to lease an elevator. Another project very well known is the Philips lighting project, of course. All the lighting tools and lighting equipment in, I think it's Terminal 2 at Schiphol Airport are for the moment are there on the basis of a leasing project with Philips. I also refer to the Dessel carpet lease or to the Uno walls, other companies that are very interested or that brand themselves as circular projects. Are circular companies. So these are also projects that are interesting from a circular economy point of view. And then last but not least, certainly not least, on the contrary, is of course the entire renewable energy sector. And I limit myself to 3 examples. We all know the solar panel lease or the solar panel solution. Then the more innovative and more modern, and as far as I'm concerned, more beautiful kind of solar panels are, of course, the solar roof tiles. If I'm not mistaken, Tesla offers the opportunity to buy solar roof tiles. And then 2 final examples: geothermic heat pumps and the combination thereof in heat networks. All these energy solutions or renewable energy solutions can be installed in buildings and other project or huge projects on the basis of a lease. And for each and every one of them, I know examples of companies that for the moment, as we are speaking, offer the possibility of leasing, for instance, a geothermic heat pump. Of course, as Mira already pointed out, one of the hugest risks associated with real estate, and in real estate we're also always talking about the numbers, and it is a risk that comes with a considerable financial risk, is of course the loss of ownership. And this loss of ownership risk is undeniably, especially linked with real estate. And that is because of some major principles of Belgian property law. The first principle is a principle that is called the unity principle, and it sounds somewhat transcendent, but it's not at all. In fact, it's a very easily understandable principle that all inherent parts of a certain object are considered to be that object itself from a legal point of view. In other words, it's not possible to have different real rights, to have a variety of real rights on various parts of an object. No, the object itself can be the object of a real right, a right in rem, een zakelijk recht, or droit réel. Just to make clear that everybody understands what I'm talking about. But it's not possible to have a separate right in rem on an inherent part of an object. And what is the problem, or what is it's not, as far as I'm concerned, it's not a problem, but what is the challenge for real estate? Well, that is that certain building components, and certain is in fact a bit of an underestimation, I dare to say almost all building components will qualify as an inherent part. Most beautiful example of this is, of course, the well-known concept of immovable accession. The movable accession is a legal concept, which means that when an object becomes an inherent part of real estate, the ownership of that object also becomes the ownership of the owner of that real estate. In other words, let's talk things very practical. What happens when someone installs solar panels on my roof? Well, principally, those solar panels become my ownership. So the original owner of the solar panels loses his ownership to me. Of course, from a circular economy point of view, that goes directly against what we want. As Mira already pointed out, it's the purpose, or it's the precise objective of a circular economy, that the supplier supplies a customer with efficiency as a service, all kinds of services. But of course, the supplier faces the risk of losing ownership of the object that he gives to the customer, the object that he leases to the customer. And that is, of course, a huge financial risk for the supplier, because it goes directly against what he or she wants. Fortunately, in Belgian law, there is a very easy and also a quite well-known solution, and that's the building lease. And building lease is a separate real right, a separate right in rem, which offers precisely the opportunity to split ownership of buildings in a horizontal way. What do I mean by splitting in a horizontal way? Well, as a matter of fact, a building lease right gives one the possibility to own a building, so to say, for instance, that is based on the plot of land of another party. So there's a separate ownership for the building and a separate ownership for the plot of land. Of course, that is the most commonly known application of building lease. But what is less known is that building lease does not only deal with buildings themselves. It can also deal with parts of a building. To give an example, a generally accepted example, solar panels can be put on a building on the basis of a building lease. So what happens then is that the owner of the building grants a building lease right to the owner of the solar panels, and the owner of the solar panels thus acquires the right to install these solar panels on the building of that other party. Advantage: the solar panels remain the ownership of their original owner. And I give you the example of the solar panels because that is a generally accepted example. Even more, most huge solar panel projects, for instance, at my home university, the KU Leuven, there is a huge field of solar panels on one of the building roofs, Well, these solar panels are installed on that building on the basis of a building lease. So that is a solution that is generally accepted. But we have a problem for other building components. What, for instance, with solar roof tiles, or what with geothermal heat pumps or heat networks? The problem is that there's a classical requirement that is posed to the building lease, and that is what I like to call the independence requirement. The object of the building lease must be capable of an independent existence. And I would like to draw your attention to the words capable of an independent existence. And again, these words sound very transcendental. And as far as I am concerned, they are. Because in the book 3 of the Belgian Civil Code, we read this requirement nowhere. As far as I am concerned, it's a requirement that is always mentioned in literature, and is also referred to in case law. But as far as I am concerned, in fact, it's a false requirement. What we need for the building lease is a modern interpretation. It's a modern and very straightforward interpretation saying that all parts, all inherent parts of a building can be owned by a different person than the building itself, on basis of a building lease right. So the general, in fact, what I am proposing is the generalization of the right of building lease. The advantages of that building lease solution are huge, truly huge. Building lease is fully transparent because a building lease needs to be registered in the Belgian land register. It ensures a value preservation that is precisely what we aim for in the circular economy, and it is also well known in the real estate practice. Most project developers are very familiar with building lease. So these three together guarantee a legal certainty that is very desirable from a legal point of view. From a financial point of view as well, the finance possibilities for building lease are rather well known and are huge. It's perfectly possible to grant a mortgage to a bank on the basis on the objects that one owns on the basis of a building lease. And then last but not least, of course, not during this webinar, the sustainability profits are considerable. Of course, what I am proposing risks to create a bit of uncertainty, because I have been talking to you about the modern interpretation of the building lease. And when one says interpretation, one undeniably says uncertainty, because the one who is interpreting something always has a kind of leniency, possibilities to interpret it strictly or to interpret it leniently. What I have therefore done is I have developed a general risk assessment framework for various components of buildings. And on the basis of that framework, it is possible to estimate whether the building lease is a viable solution or is a possibility for that building part. And my general risk assessment framework has 3 categories. Category A is a category of building parts that do not become an inherent part in the way that I have been discussing with you 5 minutes ago. It's those building components that are not incorporated in the building and that are not so functionally intertwined with the building that they are considered to be an inherent part of that building. Which components am I speaking about? Well, for instance, the perfect solution, leased furniture. Furniture is something that can be perfectly integrated in the circular economy because it's perfectly possible to lease furniture. It's done a lot of, and there is no risk of loss of ownership. Then the second category is a category for which the building lease is certainly possible, also under the classical interpretation. That is, for instance, for solar panels, but also for heat pumps and elevators. These 3 examples perfectly meet the independence requirement that classical legal literature and case law pose. A third category is a category of building components for which building lease is possible in the modern interpretation, in my interpretation, but is disputable from the classical point of view. And that is, for instance, solar roof tiles, heat networks, or facade parts of a building. So in fact, from a very practical point of view, what I am saying is that in category A and B, there is no risk whatsoever. A building lease solution is either not necessary or either perfectly possible. In category C, one must be more careful. I do not overestimate myself. Of course, I hope that I will be, from a legal point of view, influential enough to convince everybody that building lease is possible for the building components that fall within category C as well. But when project developers and real estate agents are thinking of components in category C, I'd rather advise them to be careful and to have, in fact, a very well built authentic deed that establishes the building lease, and to be extra careful towards the risks that are associated with the projects that fall within category C. So this was my brief presentation. I've tried to be as brief as possible and not to talk too much legalese. Thank you very much for your attention, and I am looking forward to your questions.
Thank you very much, Benjamin, for this presentation. We will now give the floor to Beatrice and handle the Q&A at the end of the session. There is already a question for you, Benjamin, but yeah, I think you've already answered it. So, okay, thank you, Beatrice. We can see your presentation.
Yes. Do you hear me? Yes.
Yes. Yes.
Good afternoon. So indeed, I'm a company lawyer within Agoria, dealing basically with commercial law in the broad sense of the word. I have been involved with Mira, together with the law firm DLA Piper, to draft a template for the efficiency as a service contract. And my overview will pinpoint the my purpose this afternoon is to guide you through the template contract on the basis of the risks and the concerns of both parties. As Mira already said, it is a result-oriented template. We are not talking about a product and a service which is being provided, but rather a specific output, a result, cooling, lighting, heating, whatever, without any transfer of ownership of the equipment which is placed at the client premises by the service provider. It is a pay-per-use model on the basis of certain output specifications. And of course, the services provider is hereby free to choose the means to achieve such a result. So this is quite flexible throughout the duration of the contract. Such a model is less capital intensive for the client, but of course, there is a pre-financing burden for the service provider. This contract template is only deals with the relationship client-service provider, but of course, the service provider may have to adapt this standard in accordance to the requirements of its financing parties. So that is why this template will also be submitted to comments by banking institutions in order to check its bankability. As regards the contract, the content of the contract, the obligations for the service provider are very varied. He has to produce the equipment which will be installed at the premises of the client, but he will also provide different services throughout the term of the contract: installation, maintenance, servicing, and eventually at the end taking back the equipment. So it is quite a mixture of services. So we can ask ourselves, what is the legal qualification of such a contract? Please note that this contract, of course, has been drafted according to Belgian law, and it does not cover the tax or accounting appreciation or qualification of it. This will be tackled at another seminar this week on the 5th of May, to which you are all very welcome. As from a legal point of view, is this a rental contract, contracting agreement, a license? Well, it's not clear to say, but at least it's a service contract and for long term. And when we look at the Belgian legal framework, the Civil Code, the rules are not very developed on this type of contracts. So this means that parties are quite free to agree on what the contract will provide. And the standard contract which has been drafted here is contains a core with specific clauses and also some optional clauses which can be plug in or plug out according to the specific situation of the parties. It is a quite simple contract and balanced, and of course it will have to be adapted according to the situation of each party. Don't worry, I won't go into detail for each and every clause of this contract, but I will rather give an overview of the risks seen by each of the parties, which have already been highlighted by Mira, and how these risks are being mitigated in the template contract. So first of all, what are the concerns in the eyes of the client when entering into such a contract? Well, the client, of course, he will want a guaranteed continued output, result, lumen, or a certain constant temperature 24/7, for example. And this will be more important when this is business critical. For example, a certain temperature of cooling within the food industry. So this guaranteed output will be defined in the contract in accordance with service level requirements, a minimum service level which has to be achieved by the service provider. And this is, of course, an obligation of result. When he does not reach this minimum, liquidated damages would apply to the service provider, and these liquidated damages would be reduced from the invoices which will be sent to the client for the output. Now, these service levels concern, on the one hand, the availability, which has to be guaranteed, but also, in case of unplanned outages, the maximum response and resolve time for resolving the problem. So normally, the contract provides that this is the sole remedy, these liquidated damages, in case the minimum service levels are not achieved. This in order to have a balance between the parties, the obligations of the parties. But of course, should this failure be continued over a certain period and really be very important, this may amount up to a serious breach. And in that case, there is a right foreseen in the contract template for the client to discontinue the contract. We will come back to this later. Of course, the client also wants it all in. He wants to be fully relieved from any obligations as regards the output which is to be provided. So the contract also provides maintenance remedy by the service provider in case of malfunctions, and the service throughout the duration of the contract term, which can be quite long. It has always to be as energy efficient as possible. How do we achieve this? Well, in the contract template, the cost for the energy supply is borne by the service provider. So this means that this is an incentive for the service provider to have its service provider equipment and the service levels as efficient as possible. And for example, he's entitled, as it is foreseen in the template, to replace its service provider equipment or parts of it with more advanced or improved items throughout the contract. So he's free to adapt what he's using in order to achieve the output in a most efficient way as possible. There is also an optional clause which obliges the service provider to submit a yearly improvement plan to the client in order to achieve such an always up-to-date and innovative as possible solution to the client. Now, what happens if this guaranteed output is not provided by the service provider? I already said that there are liquidated damages which may apply, but in case of unplanned outage, the contract also allows the client to seek for an alternative only for this temporary period of unplanned outage where the service provider cannot solve this outage. And of course, it may not impact the functioning or the service provider equipment. Now, in case of material interruption or disruption, so this is not the situation where just the service levels have not been met, but really where there's a material failure on behalf of the service provider who does not remedy this within a certain period of time, there is an optional clause foreseen where the client can step in. So this means that in such a situation where the service provider is not able to remedy, the client himself can take things in hand and solve the problem itself, or by appointing a third party who will provide the output in place of service provider at the cost of the service provider. Actually, this should only apply in a limited situation where there's really a systemic failure. And the reason of such an optional clause is really to avoid an early termination of the contract. Now, if things really don't work out as they should, there is also a possibility foreseen for the client to exit the contract prior to the contract term. But this is only really in limited situations in order to have a balance between the parties. It's only in case of insolvency of the service provider, material breach, which does not cover just not meeting the minimum service levels. And also in case, and I told you before, in case the liquidated damages when the service provider does not reach the minimum service levels is continued and exceeds, for example, 50% of the fees that would otherwise have been due over a certain period of time. Only in that case, when it's really becoming material breach, in that case, the client would be entitled to terminate the contract prior to the contract term. And that in those situations, you would also apply a termination fee by the service provider. So this is to allow the client and really to incentivize the service provider to achieve correct compliance with the contract. Now, for the service provider, what are the concerns, his concerns in order to enter into such an agreement with the client? Of course, he wants to be paid for, or he has to be paid for the guaranteed output. So the template provides in a monthly payment as from the supply of that output on the basis of a fee, which contains several components. And of course, this fee covers everything. It covers both the equipment, the design of it, production, installation and commissioning, as well as the maintenance and servicing throughout the contract, and the output, of course. We have foreseen in the template a minimum capacity use. So this means that the client has the obligation to use a minimum amount of the monthly contracted supply. This in order to avoid this volume risk, which was commented by Mirja. So the price, how is it established? You have several components, but of course this can be adapted between parties. We have first foreseen in a capacity charge for making the contract supply available, a usage charge, which is based on the usage, on the basis of the units which have been used on a monthly basis. How do we monitor, how do we follow up these usage? This is on the basis of a measurement tool, which is to be provided together with the equipment by the service provider at the client's premises. And of course, we have also foreseen a shortfall charge, which would only apply in case this minimum capacity use has not been taken by the client. So in order to enable an as stable as possible fee and predictable for the service provider. The opposite, in case too much or more units have been used than what was foreseen contractually, there would be a capacity excess charge, which may apply to the client. We have also foreseen a price adjustment in case of indexation, and this would also apply for the energy cost borne by the supplier. Just note that the client has a right to suspend his payments, but only in very specific circumstances, and namely in case of amounts which are disputed, so which he contested on time, and also in case of material non-performance of the service provider. So not only when not reaching the minimum service levels. What happens in such case? Well, then automatically parties are referred to a dispute resolution procedure where they have to negotiate in good faith in order to reach a solution which works for both. Of course, the service provider, he also wants the client to use its equipment correctly. So there are some clauses covering the obligations of the client regarding the equipment provided by the service provider. So he may only use it, for example, for the sole purpose of receiving the output. He may not interfere or change the equipment. And of course, if there is any repair or replacement to be made due to such undue intervention by the client, it will be at the cost of the client. Benjamin already mentioned it. There might be some questions regarding the ownership, which remains with the service provider. So the template repeats the fact that the service provider is the sole owner of the equipment, and also provides that such equipment is to be labeled with the name of the owner and which shall not be removed by the client. Also, it provides that it cannot be transferred to another location by the client, nor the use of it can be transferred to third parties without prior consent. And of course, in case of insolvency or another situation of the client, the service provider will be entitled to remove the equipment. The client also have an obligation to inform third parties on the fact that this equipment remains ownership of the service provider, and he has to notify the service provider in the event there would be any risk or infringement of his ownership rights. This is, of course, only valid between the parties. And as Benjamin stated it, there is a de jure accession right when the service provider equipment is inherent or becomes inherent in the client premises. So that is why we have actually provided an optional clause establishing a building lease, as Benjamin said, or superficies right, as it is called here, which obliges the client to establish such a notarial deed together with the service provider upon conclusion of this agreement, in order to ensure that this ownership of the equipment remains with the service provider and becomes also public towards any third party. As regards the client premises where the equipment of the service provider is installed, we have also provided some obligations for the client, for example, to maintain its promises in good order, and for example, that the conditions regarding humidity, ventilation, etc., have to be at a certain level in order to also maintain good functioning of the equipment of the service provider and to guarantee the correct output. This is equally important, next to other obligations like providing the necessary power supply, appropriate insurance coverage and notification of the presence of the service provider equipment to the insurer. And we have also covered or addressed at least the situation where the client is maybe an owner of the premises, but rents it out to a third party, or where he is the tenant of the premises, but not the owner. In such case, it is important that the client commits to have the relevant obligations also complied with by that third party, being the owner or the tenant of the premises. As I already said, there is in the contract foresees a measurement tool, which is to be provided by the service provider together with the equipment installed at the client premises. This allows monitoring of the usage and the correct use of the equipment, and also allows to check the outputs and whether the service level requirements are being met. Of course, this measurement tool will collect client data. As you all probably know, if in case it concerns personal data, it will have to be GDPR compliant. But next to that, all client data are also to be governed in the contracts in order to allow the service provider to use those client data for the purpose of providing the output, but also to allow him to monitor his equipment and improve it and follow it up. So this is also an important part where, of course, you will have a software aspects and possibly some connectivity details to be set up together with the client. Now, also the service provider might have a right to suspend in case of failure by the client. What are the obligations of the client? Well, essentially to pay. When is the service provider allowed to suspend his services, his provision of output, in case undisputed amounts are not paid, only when these are undisputed, but also when the client materially defaults, when this affects efficiency or safety of the equipment, or when he refuses access to the service provider to the client premises in order to check up his equipment, or in case of client insolvency. So these are quite delimited circumstances in order to have a balance between both parties. And if things go wrong, also the service provider has the right to exit the contract prior to the contract term, but this would only be possible in case of client insolvency, or if 3 undisputed invoices are overdue, are not paid, or in case of material breach, which does not, of course, cover not reaching the service levels, because this would be limited to liquidated damages only. In that case, similar to the situation in case of failure by the service provider, there will be a termination fee applicable to the client, which may be similar to the one applicable to the service provider in case of breach. Now, we have dealt with the risks or the concerns for each party, but of course, the main object of this contract is to establish a long-term partnership, and it's in both parties' interest to have the contract as long as possible. So, as regards the contract term, we have the template provides an initial contract term during which, in principle, early termination is not possible. The template provides an initial contract term with therein a partial fixed term. So it can be modulated, of course, or you can only provide an initial contract term, but at least there is one part of that fixed term where a termination for convenience by the client is not possible. Once this fixed term is passed, client could terminate for convenience, subject to notice period, without any compensation. Now, after this initial contract term, the template provides for the possibility of several renewals, but of course, in that case, it will be subject to negotiation of its commercial terms. So it's not just renewal at the same conditions, as we thought that this may be difficult when the initial contract term is quite long. There is also an optional clause allowing the client to purchase the service provider equipment at the end of the term at fair market value. But there it will be important to check also the accounting principles in order to keep the equipment off balance of the customer, of the client. And so the conditions of such a purchase option may have to be checked in that light. Also, in order to have a smooth cooperation, the template provides of several mutual notification obligations, as the duration of the contract will be quite long. So in order to have a smooth cooperation, the client will have to notify in case he sees some defects with the output or the service provider equipment, in order for the service provider to be able to intervene as quickly as possible. In case of overdue payments, the client also has to provide some solvency information to the service provider. And there are some optional clauses also dealing with cooperation between the parties. For example, in case the service provider needs some financing information as required by financial institutions, or in case of post-termination assistance by the service provider to the client. So these elements tackle more or less, I think, the most dominant or most important issues when entering into such agreement in the long term. But of course, I'm happy to hear any comments or requests, questions you may have in this regard. Thank you very much.
Thank you very much, Beatrice, for this very clear presentation. Something that I forgot to mention, this standardized agreement was developed on the one hand to support companies that want to engage in efficiency as a service. As Beatrice mentioned, there isn't any very developed legal framework that surround such type of contract. So it could be a bit difficult for companies that want to engage in such a business model to know a bit how to establish this contractual framework, but also the aim is to increase the acceptance of such a business model. So servitization is really, we are seeing much more I would say emerging servitization projects. So Benjamin mentioned about the facades, because we're talking about facade as a service, roof as a service, and anything as a service. But still, it's business model that is perceived relatively risky. And the idea is by having a standardized model, it's also the aim to reduce the risk perception from the customer side, but also from the financing side. So as Beatrice mentioned, this contract will also be sent to financing partners for them a bit to comment and to assess whether such contract properly covers the risks. So please, if you have any questions, or also if you have any feedback with regards to the standardized contract, at least with regards to the presentation given by Beatrice, do let us know, because it's an evolving document. So there is a possibility also for us to amend the document to really ensure that we can provide something that is suitable for all parties to this tripartite relationship between the customer, the provider, and the financing institution. So now we'll give the floor to Ruth for the final presentation.
Yes, thank you. Yes. So hello to everyone. I will continue the webinar more specifically on the energy fluxes. So we talked about a lot on efficiency, of course, but to power the solutions, the technologies, for instance, heat pumps, lighting, I've heard, we also need electricity. And the way we can handle this electricity flows, this is also something that is being regulated at the European level and also in the different regions. So a lot of things are happening, and we are going to discuss how it can enable also efficiency as a service. So maybe the most important pieces of legislation are the Clean Energy for All Europeans package that was launched in 2019, well, in 2018, but there were several documents. And it really is, was launched by the European Commission to really put the consumer more centric. So really the consumer as a center of the energy transition we are now going through. So basically, there are two directives and also regulations that are very important, which is the Electricity Directive. We also sometimes say there's an Electricity Market Design Directive and the Renewable Energy Directive. These pieces of legislation have been transposed or are being transposed at regional level. At Flemish level, we have the Energiedecreet, Energiebesluit, and also some more technical regulations that are being transposed and finalized at this very moment. The Walloon region, very recently, we had the Decree Market Design that is being finalized at this very moment, and also in the Brussels region, very recently, we also have an ordonnance, which is the Brussels legislative piece to reform the electricity market. So a lot of things are going on, but as we will see, also a lot of things also still need to be finalized, enabling energy as a service, because of course I'm speaking now about energy, because we need also energy for it to be efficient in your applications and technologies. Maybe some new concepts that have been introduced by this Clean Energy for All Europeans package, or the EU Clean Energy package. I'm not going into the details, but some of the concepts are, for instance, active consumers, whereby every consumer is able to store electricity, to share electricity, to join a renewable or a local energy community, which is the second one. I'm not sure if I have a pointer or not, maybe it's not necessary. Dynamic pricing, which means that for the moment we have energy, we have a fixed contract, or we have a contract based on a monthly or seasonal indicator. It is also possible, as many industries already have, to just pay the actual real-time price at this very moment, and then you pay at the end of the month the average, or you get a very direct price signal of the actual price. So this is also something that is being pushed or put forward by the Clean Energy Package. Energy sharing, energiedelen, peer-to-peer trading of energy, the specific case where you have solar panels and your neighbor doesn't. Is it possible to share the electricity of the solar panels? So we're not talking about the hardware, but really about the fluxes of energy with your neighbor. Maybe something that is maybe not really specifically efficiency or energy efficiency, but that can really have maybe a complementary role, and I will also briefly touch upon it, is flexibility, because also services enhancing the flexibility are being put forward and can also have a financial benefit. For instance, demand-side response, the possibility to store electricity, all these kind of roles are also being developed, and again, also renewable customers that are together being taking actions on the self-production they have. So, well, of course, these concepts are also interlinked. So, for instance, local energy communities, it is actually about energy sharing between the participants. It's also possible to have a flexibility service and to be rewarded for the flexibility you can have to the grid. There are very there are many interconnections between all these concepts. But maybe to start off also is the legal framework or the policy framework is not everything. We also need it to be working in practice. And maybe you've also heard that in Belgium, we now have a data platform, EaaS, which is actually the hub collecting all the data, because of course, this is about data. If you want to share energy from your solar panels with your neighbor, well, then this is a question of sharing the data, how much, who is going to control this, how much should be deducted, for instance, for your energy bill. So this is really about allocation of data, reconciliation of data, and therefore there is a software platform, but it also is very, I would say, rather new. It also has still some teething problems. So the regulatory framework is not everything. We also need to have it in practice with a working software platform. So maybe as a general remark before we go into the details. This is also, I think, maybe my key message is that, of course, the policy framework enabling efficiency as a service, but maybe energy as a service is still being developed. I think maybe if we speak about energy as a service, we often think about multiple tailor-made suppliers that you have as a consumer, for instance, multiple contracts, for instance, one for your electric vehicle, one for the electricity for your heat pump, one for, I don't know, something else for your lighting, for instance. This is not yet happening. It is possible in practice, but for instance, in the Flemish region, it is in practice only possible, for instance, for your EV, that you have a specific meter for your electric vehicle. In the other regions, as also mentioned, decree or the ordinance is just being developed. Still a lot of hurdles have to be taken on a regulatory level. Energiedelen, I will also briefly touch upon that for the Flemish region. It is possible as of this year, but only for consumers within the same building. So for instance, the neighbor in another house next to you, it's not yet possible. From a regulatory point of view, it's possible. From a practical point of view, it's not yet possible, but it will of course be possible in the next couple of months, hopefully. Dynamic pricing, and actually in practice, this is already possible. Industrial companies also have it already, but of course, a lot of things, and I think a lot of things in general of this policy framework are also dependent on the rollout of digital meters, because of course we need digital meters to capture the data to become more efficient to share energy flows between different consumers. So a lot of I would say the practical application of all this is dependent on the rollout of digital meters. Then flexibility services, I will also touch upon that. And then energy communities as a general concept. There again, we have the regulatory framework, but the practical implementation, for instance, in the Flemish region is only foreseen by beginning of 2023. Maybe you've said, okay, but there are already energy communities. Yes, we have quite some pilot projects already, but this is of course a bit beyond the regulatory policy framework. So these are pilot projects, they're often also subsidized, but they're not always, I would say, a correct transposition of what is possible from the European directive and regulations, but of course they are needed to a bit create awareness on energy communities. So maybe energy communities, because it's of course a very big concept. I would also say the European policymakers haven't made it very easy, because we make a distinction between citizen energy communities and renewable energy communities. And actually the objective is that you have economic or social or environmental benefits for your members. This can, for instance, be that you have a joint infrastructure for charging electric vehicles, but it's not, the objective cannot to make profit. So it always has to be secondary to another primary objective, which is also already some, I would say, a regulatory constraint. Then there are some differences. For instance, renewable energy community, it has to have a local boundary, so geographically. Of course, it needs to be only taken into account renewable energy. And then there are also some rules on who can have control in the energy community and who can be a member. And I think in general, it is really about a bottom-up participation of citizens. So it's not really like some actress taking an initiative and setting up an energy community. No, it's really a bottom-up citizens that work together. This is the idea. It's also not the idea to create a microgrid as an alternative to the public distribution grid. It's more to use it more from a more efficient point of view and stimulating, for instance, more the integration of renewable energy. So maybe not too much in detail. So the Flemish framework, I will give some more details on where you can find everything, but this is the most developed framework from the 3 regions. As said, it is dependent on the rollout of digital meters, but also the technical readiness of the distribution system operators. In the Flemish region, this is Fluvius. It's also dependent on how data can be exchanged already from a practical point of view. This is, for instance, a figure by Fluvius, and here you see energiedelen, so sharing of energy between different consumers. Only from this year, energiedelen in één gebouw, so in one building, for instance, an apartment block. It is already possible since this year, but more difficult ways to share energy between different offtake points or different afnamepunten. This is only in practice. In theory, it is already possible, but in practice, it is only possible as of 2023, 2024. So I think this is also a very important message on the feasibility of a lot of schemes, that this is really taking a lot of time to make it practically available, unfortunately. Maybe energiedelen in one building, so sharing energy between for instance, different apartments or flats in one apartment block. It is in this current framework, it's not that you get a preferential treatment. So it's really only about sharing energy, for instance, the commodity of solar panels, but it's not that you get, for instance, a lower grid tariff. That's not the case. Every flat still has its own EAN number or EAN code. And I think this is also something that is coming up from the European framework. It is not possible to have, for instance, different EAN numbers together and to put them together and then to have a specific tariff for that one, or to have one supplier for that EAN number, only if it's, for instance, the collective rooms in an apartment block. But it's not possible to have one supplier for all EAN numbers together as an, I would say, from a top-down approach, because that would imply a private distribution grid, which is something that is not allowed by the European legislature. So every offtake point, every EAN number is still something individual, and every flat can also choose to have its own supplier. This is also defined by the legislation. So it's not an overhaul, I would say, of the current market design. Flexibility, this is in Dutch, some examples of what is flexibility. It actually also means that you get, and I've here put the definition, it means that you change the way you consume, it changes the way you inject, for instance, electricity from your solar panels, or the way you generate electricity, for instance, with a wind turbine or solar panels, in response to an external signal. And this can be from, for instance, because there are some congestion problems within your neighborhood, or because there is a voltage problem. It can be the distribution system operator Fluvius who is in need of flexibility. And there is a lot of flexibility available. This can, for instance, be flexibility from heat pumps, that they can be their offtake of electricity can be lowered, or they can even be they can maybe all set up together at a certain specific point in time when it's needed for the flexibility of the grid. Is every consumer doing this themselves? It is in theory possible, but most of the time this will go via a flexibility service provider, a third party. So these kind of rules, I would say, are now being developed. These are market parties, for instance, that are interested in, okay, I have a portfolio of different consumers and I'm giving them an incentive to create flexibility, for instance, to lower their demand at a certain point in time. And altogether, this is an interesting amount that, for instance, can help the local distribution system operator. There are many possibilities. There are also, from a technical point of view, many ways to look at this flexibility, but I think it gives you an idea. This is not about energy efficiency, but this is about flexibility, because of course, with a lot of renewable energy in the grid, we also will need more flexibility in the grid to not have congestion problems, voltage problems. So this is really about this. So it's not really efficiency, but maybe it's something that we can consider complementary. And I think definitely from a technology point of view, there is potential, and maybe to take it into account into your business model as well. Very short on the Walloon and the Brussels framework. So as mentioned, it is still being developed, but what they already said is that here there probably will be a link with the grid tariffs. So the tariff methodology, this is the way as a consumer you're paying for the grid costs. And there they say at least they will define some advantages for instance, energy communities, or if you're using it, if they can prove that it's using the grid more efficiently. Of course, this is still being developed, and we don't have any more details at this very moment. The Brussels framework, again, it's very, we only still have the very general policy framework, but what they will be doing is that they will create a facilitateur. So yeah, I would say an institution or someone at the administration to help you out and to set up these energy communities. So maybe the Brussels and the Walloon framework is less being developed, and it's still, well, there will still need some extra activation to have more projects. So maybe as a general remark, let's start with this, or let's maybe a bit more focus on energy as a service. So having more than one supplier, and maybe per application, because this is maybe where we're going to. And I would say energy as a service, so really the energy element of your energy efficiency contract, I think it is rather limited. There are some possibilities. The fourth one is the one has been discussed by Beatrice, but there are maybe also some others, and I would just give you the, in my opinion, the extensive overview. So flexibility provider, it is possible that technology companies can take a role as flexibility provider, where, for instance, you're aggregating the flexibility potential of, for instance, heat pumps. You have a heat pump portfolio. You know that they can switch off, that they can also switch up. I'm not sure if you use that word. By giving an incentive to your portfolio customers, you can use this flexibility and buy and sell it, for instance, to a distribution system operator that is willing to provide you with a financial compensation for this offered flexibility. This is something rather new, but it is possible from a third party to take up this role. Of course, you need to respect all the technical details, the technical reglementen that need to be fulfilled within this flexibility framework. Energiedelen, so sharing energy with third consumers, of course, it is also possible. As I've mentioned, it is only possible within the same apartment. So for instance, if you have different lighting or heat pumps again, or electric vehicles in one apartment building, it is possible to share this electricity between the different flats. And as a third party, for instance, you can facilitate this. This is, for instance, also a role that can be combined with the energy efficiency as a service role as you can maybe have as a company. What, of course, is also possible is that you become an energy supplier yourself. So, for instance, for the heat pump or the ventilation unit or the car, that you have a specific EaaS meter only for that electricity or power offtake, and that you become an electricity supplier for that specific amount. This is something rather new, and it also would, from following the current market design, that you have all the obligations a classic traditional energy supplier has. So you need to make sure that there is a balance between supply and demand on every moment in time. You also need to respect the metering and all kinds of technical elements that are specifically in a technical reglement, which is actually well, I would say the piece of legislation that is saying how electricity flows or gas flows are now being handled between distribution system operators and suppliers. But of course, there is also a fourth way, and I think this is the last one, and probably also the one that is being used right at this very moment. You can also just partner with an existing supplier. It can be an energy supplier, or it can be an aggregator that is having flexibility in its portfolio. This is, for instance, that you are willing to compensate, for instance, the energy part of your application's energy consumption as a share of the total energy bill of an individual consumer. This can be, for instance, you have this specific classical EaaS meter, but then you have a sub meter behind that meter, and you agree with the energy supplier, for instance, that you will be paying for that piece amount of the energy consumption. So this is something that is a commercial, I would say, negotiation with existing players in the market. And there are many possibilities, of course, but this is, I would say, this is an approval with you and the classical parties. Is this really consumer-centric? Well, we have some voices that say this is not going far enough, and I also would like to give you, as interested parties, an insight already in what the future might bring. For instance, EaaS, which is our transmission system operator, every year they publish, I would say, a more visionary document on how the energy transition or energy market should look like. And in a few years ago, they had a white paper on a consumer-centric electricity system, whereby they had some, I would say, some visionary insights in what should be, well, the future. Of course, now we have a meter at home or in our company, and there are only a limited amount of services that you can add to this meter behind this meter. But it's not that you as a company can already take up, for instance, the electricity for heat pumps, for instance, or for the lights in an office specifically directly with the consumer. No, it is only possible if you're a supplier, and if there is a willingness to set up you need to set up a really specific official meter. So it is hardware related, and it is what it is. It is the traditional way of looking at electricity flows. So Ilya in this position paper, which is, again, it's very visionary, says, yeah, we need to go to an energy as a service market whereby all kinds of players and I think specifically also the people that are in the call could also be able to provide these kind of services. So again, it's very visionary, it's the future, it's not yet there, but for the moment, as I've mentioned already, energy suppliers need to make sure that at any moment in time, their supply of energy and demand of energy is in balance, specifically, of course, for electricity. So that means that all connection points have to be in balance. Of course, this is a very physical way of looking at things. And in this paper, Ilya says maybe we should go to a more innovative services, that you don't need to have this specific hardware physical connection, and that there maybe might also be services applied, offered not by your main supplier. But for the moment, services or need to be offered by the main supplier, Engie, Luminous, Eneco, and others, of course. If you really want to have, for instance, for electric vehicles, your own other supplier, then you need an other access point, an other EN meter. It needs to be duplicated, so it needs to be a regulated meter. And there might be some, or you need to work by complex, they say, administrative arrangements. For instance, via an EaaS contract, as Beatrice explained, that, for instance, you have a service as a company, but you need to do it via a contract with your with the energy supplier of your customer. So you need to have a workaround technically. So respecting the current market rules. I will not go into detail of one is this changing, because we don't have any maybe position on this or how this does change, but of course it is a future discussion, and which would also need to take into account some elements. For instance, everybody should also contribute to the non-energy aspects of the energy bill, because it's not only about electricity, we also pay taxes on top of this electricity price. How if you have 5 suppliers, one for your car, one for your heat pump, one for your lighting, one for all the rest, are you well, fairly contributing to these other aspects, social obligations, green obligations? How do we make sure that everyone is involved, that it's not only the one that are very consumer centric, I would say the front runners, and that we get everyone in this thing? These are just some general questions also posed by Ilya. It's not my discussion. And of course, also if we have sub-meters or, making up this market design, how regulated should these meters be? Because of course now the meters are very regulated, but if we're working with sub-meters, do we need to respect common standards, protocols? So there are still some, I would say, some questions, some discussions, but I think it was just my idea to give you already a grasp of how some parties in the market are looking at the future electricity market. So if you would have any questions, then I'm happy to answer them.
Thank you very much, Ruth, for this quite comprehensive presentation. So we actually do have a question for you. So becoming an energy supplier yourself, isn't this very complex procedure? In that case, you will be submitted to regulations of electricity gas suppliers.
Yes, absolutely, and this is I would say the way it is for the moment. So if you're becoming an energy supplier, then you also need to respect the, I would say, the balancing, for instance, from the energy from the whole of your portfolio and all the regulations. So I'm also not saying that this is a very feasible, but in the current framework, if you really want to I would say, bypass the current scheme where you have grid operators, where you have meters, where you can choose one supplier per meter, then you have to become a supplier yourself. Only, I would say, in the future, or via partnerships with existing suppliers, it is possible. But if you want to bypass it, it is not yet possible in the current framework. That was actually my idea, and I know it's not maybe the most feasible one, but maybe some parties might be thinking of becoming an energy supplier themselves and taking up the risk, a word that is being heard today often, to take up the risk and have all the same regulations and requirements as traditional energy suppliers. Yes.
Okay, thank you very much, Ruth. We also have a question for Beatrice. How does the contract deal with the assurance of the service provider's best efforts in order to obtain the best energy prices in the market?
Yes, I think it is in some way linked to the presentation of Ruth. Of course, it will depend on how the energy supply is being provided. Is it the client who has a contract with the energy supplier and who will prorate the energy cost for the service provider equipment and output in order to deduct it from the invoices he receives from the service provider, or the other circumstance, which is also foreseen in the template, where the service provider pays directly the energy price to the energy supplier. So in that event, in the last case, we suppose that the service provider will try to get the most interesting, most competitive offer. In the first situation, of course, you might want to provide a benchmarking obligation in the contract, obliging the client to, at a regular interval, benchmark his energy contracts against other offers in the market in order to have the most interesting one applying to the contract. But this is to be checked at on a case-by-case basis. But I think this could be an option to provide such an obligation for the client to evaluate at regular intervals his energy conditions which he contracted with the energy supplier. I don't know, Ruth, whether you have any comment on that.
Yes, exactly. I think it is of course the good way to go along with these what is market tendencies. Of course, in the current situation, even with existing suppliers, you never know if you had the best contract. So I think this is always a risk. What is the best contract in a given situation? You never know what the market will be doing. So yeah, I think you just have to follow the logic Beatrice explained, but it's even for existing suppliers, there's not something as we had the best contract. You never know when you conclude a contract that this will be in the next couple of years still be the best contract. Yeah, you never know. Sure.
Thank you. I think Dimitris, you have a question for Benjamin.
Oh yes, thank you, Mira. Very briefly, it was very interesting to see these different categories of lease that you had on your slide, and I was wondering in Belgium if supplier is interested to supply cooling as a service, in which category does it go, and how can they ensure that they place themselves in a particular category?
Well, for cooling as a service, I suppose it will either be category B, either category C, all depending upon the factual integration of the cooling installation in the building. There are cooling installations that are rather superficial, like there are also ventilation systems that are rather superficial, for which a building lease is undoubtedly possible. So then we are in category B. But I think as we evolve towards more sophisticated cooling systems or ventilation systems, we will move towards category C. It's not a very strict I think the difference between the three categories is more of a gradual nature than of a very strict absolute nature. So, but in any case, I still believe that both for category B and category C, building lease or right of superficies remains perfectly possible.
Thank you very much, Benjamin. So we're reaching the end of the webinar. If you have any questions still, you can still reach us by email. Before closing the webinar, just wanted to mention again the last third webinar that we're having this Thursday on the financial and accounting application of efficiency as a service. So in this webinar, we will a bit cover the financial aspects of providing an efficiency as a service solution, the partnership with the financing institution, and as I mentioned, the three-partite relationship between the supplier, the financier, and the customer. We will also look into the accounting implications with regards to the question of the on and off balance sheet of the equipment, be it on the supplier side, but also on the customer side. We know that it's a question that generates a lot of, it's a topic that generates a lot of questions. So we will have a presentation on that. So thank you very much for your attention. You can see here our contact details. So please don't hesitate to reach out to us. And hopefully we will see you also on Thursday for our third and final webinar. And I would like to thank very much also our speakers for today, Benjamin, Beatrice, and Ruth. Thank you very much. And let's keep the discussion going. Have a nice afternoon. Bye-bye.
Thank you, everyone. Bye-bye.